All right, I think we can get started. Is the mic working? Yes. Welcome, everyone. Can you hear me? Okay. Chris Cervanek, the Associate Director at the Center for Civil and Human Rights. Welcome. Thank you all for spending your lunch hour with us. I'm pleased to introduce to you Professor Alvaro Paul of the Catholic University of Chile in Santiago. He's with their law school, and he'll be speaking today on the Inter-American Court's interpretation of the American Convention on Human Rights. Professor Powell has spent about 6 weeks with us now as a visiting scholar with our center. And as many of you might know, Notre Dame has a special relationship with the Catholic University known as La Católica. We have an ongoing formal agreement to share faculty and students. So if there's any JDs in the room that would be interested in studying in Santiago, there's a formal arrangement permitting you to study at the law faculty there. Come up to me afterwards. I'd be happy to fill you in on a little bit more. And so it's really wonderful that Professor Powell is here as an exchange visitor, essentially, and it'll deepen our relationships, the relationships between the two universities. Of course, it's now summer in Chile, and he chose to spend the deepest, darkest, most bitter weeks of our winter up here, and we really appreciate your giving up some time on the beach to instead be with us, especially under the circumstances and the rough couple of weeks we've had. So some background on Alvaro. He is a member of the Chilean Bar and has a doctorate from Trinity College Dublin. His doctoral thesis dealt with evidence before the Inter-American Court of Human Rights. He's been a study visitor at the European Court of Human Rights, an intern at the Inter-American Commission, and a professional visitor at the Inter-American Court. And he's published extensively in both English and Spanish. And so without further ado, please join me in giving a warm welcome to Professor Alvaro Paul.
Well, thank you very much. I would like to thank the Center for Civil and Human Rights for inviting me as well. I also thank you very much for saying and making it clear that I'm from Chile, because I know that otherwise some of you would have been distracted during the whole talk, thinking, instead of being concentrated on the talk, thinking, where does this guy with a weird accent come from? So I'm just happy that that was made clear. The theme of my talk today is interpretation before the Inter-American Court of Human Rights. Most of you know what the Inter-American Court of Human Rights is, but just in case some of you doesn't, I'd say just a few words. It's a supranational tribunal which is in charge of applying the American Convention of Human Rights, and it just assesses whether states have violated human rights in particular cases. It is something very similar to the European Court of Human Rights, but in the Americas, although it has some important differences. As you may know as well, the US hasn't submitted itself to the jurisdiction of the court. And our idea today is to speak a little bit about interpretation of the court, and I'll just make a few, I'll tell you what's going to be the conclusion of this talk. It is that the Inter-American Court has very interesting ways of interpreting the convention, and that sometimes those novel ways of interpreting the convention may have some drawbacks or may have some problems. Why? Because it may interpret the convention in a very extensive way, establishing some rights that weren't actually established in the convention originally. You may say, I mean, what kind of nonsense is this guy talking about? I mean, we all want a place where human rights are respected, and the more, the merrier, okay? I agree with you. All of us who believe in human rights think exactly the same thing. Our ideal is a place where the highest number of human rights are respected, where there's no torture, no extrajudicial executions, no forced disappearances. We all agree on that. However, it may happen that I consider that some things are human rights and some other things are not human rights. the same thing will happen with you. I mean, when it comes to the small or very detailed human rights, you'll see that there are different conceptions of human rights. Probably the most typical ones where there is a clear difference of conceptions of human rights is, let's say, the right to life, whether the unborn has or not a right to life. When it comes to freedom of speech, which kinds of restriction on freedom of speech are adequate or not. When it comes to freedom of religion, does freedom of religion include or not freedom from religion? Well, it happens that the framers of the convention are aware of these different concepts, and that's why they have either taken a position or have abstained from taking a position. I'll give an example of both. The Inter-American Court of Human Rights, for instance, took a clear position when it came to freedom of expression. It took a position which is much closer to the US approach to freedom of expression than to the European approach to freedom of expression. Some authors, like for instance Joe Pasqualucci, who is a renowned scholar in the inter-American system, has even said that the American Convention enshrines the Brandenburg test when it comes to freedom of expression. And there are some other areas in which the court simply acknowledges that there is a diversity within the Americas and it allows different states to uphold different conceptions. For instance, when it comes to freedom of religion. It doesn't take, in that case, the US approach. It doesn't say you cannot establish a religion. There cannot be a established religion. Why? Because there are different approaches to that area as well. So it allows countries such as Costa Rica to have an established religion, and well, at the time when the convention was enacted, there were even more countries that had established religion. So it allows this kind of difference, different approaches. Well, and after this brief introduction, I think that we can dwell into the actual theme of the presentation, which is interpretation. Interpretation is not an easy theme. It has different. It's a theme that can be approached from different angles. It is complex because if you focus too much in one angle, you'll be dismissive of a different one. In spite of the fact that most of them, that all of them are important. I'm going to approach these different ways of interpreting the convention by giving as a brief introduction for each of them a quote from somebody who has said something interesting about interpretation. The first one is a quote from the rapporteur of the Working Commission of the American Declaration on Rights and Duties of Man. Well, that's a document which is not the American Convention on Human Rights, but it's within the system. And this man said, "The wording of a matter of this importance, of the Declaration, is of such an exquisite nature that we were often overwhelmed, and many times we had to adjourn the session in order to look for an adjective that would express our thought." Well, this man said this in Spanish, so if there's any problem in my translation, that's attributable to me and not to this man. Well, this shows a very important issue, which is that textual interpretation is very important. Why? Because states, when they are drafting a convention, when they are giving powers to an international body, they are very much aware of what they wish to handle to the jurisdiction of this body, or they are very aware of the fact that they shouldn't commit to more things than those to which they're able to commit, or than those of which there is an agreement for them to commit. And so that's very important, especially because of the fact that international law places a very important, gives much importance to the idea of the will of states. The legitimacy of most norms of international law stems from the will of states. The same thing with the powers of international bodies. Of course that there are exceptions to this big rule, but we don't want to dwell into those things because the sheer issue of interpretation is very wide, so I won't be able to delve very much into all these themes. The importance of textual interpretation has been acknowledged by international law, mainly in Article 31 on the Vienna Convention on the Law of Treaties. This article says that treaties should be interpreted in good faith. That shows you that whoever is interpreting a convention should try to actually look for the meaning of the norm instead of trying to find a loop and subvert the idea of that particular convention. In accordance with the ordinary meaning given to the terms, that's the first element, they have to take into account the text. Then the terms should be interpreted in their context and in light of its object and purpose. Those are three elements which somehow have some kind of hierarchy. If the text is clear enough, there's no need to go into the context or go to the object and purpose of the treaty in order to find some kind of second meaning to those norms which are really clear. I don't think it's necessary to dwell very much into this, but if somebody has any questions about this, I'd be happy to answer it at the very end of the talk. The Inter-American Court has explicitly said that it follows and upholds the interpretation system of the Vienna Convention on the Law of Treaties. However, several scholars have said that the Inter-American Court has had at times some problems when using this system. Of course, in general, it does apply properly, but some scholars have said that there have been some problems when it comes to interpreting the text of the convention. They say that at times the court has been dismissive of some text of the convention and has focused in only some other part of the convention. Let's say it has it has extended, for instance, the rights that are in a particular norm in a way that would go actually against another norm of the convention, and they have said that that's not the best thing to do, because it may render the text of the convention a little as something a bit or somehow irrelevant at times. I can give you some examples by the very end if you're interested. Another problem that some scholars have found is when it comes to the context. Even Judge Villagrossi said this in a particular case. He said that the Vienna Convention on the Law of Treaties specifies very clearly in Article 31, paragraph 2, what constitutes the context of a particular convention, of a particular norm. The court, however, has dismissed that particular article and has considered that the context of the American Convention on Human Rights is not only what is stated in Article 31.2, but all norms of human rights. It says, well, the American Convention on Human Rights is a human rights convention, therefore it should be interpreted in its context, which goes beyond Article 31 of the Vienna Convention and would extend to any kinds of documents which are around there, be them binding or non-binding, as long as they refer to human rights. And by doing things like that, it has established, let's say, things which are very good, things with which we all agree, such as the rights of the disabled people. However, it has done so as saying that they are that they have been provided for in the convention, which is something that would be stretching things a bit too far. And then another problem that may make the court interpret the convention in a very extensive way is the idea of the object and purpose of the convention. The convention has a very specific object, which is to establish a catalog of rights and establish a system whereby those rights can be enforced. However, the court has also broadened the object and purpose of the convention by saying that its object is to protect human rights. Well, that is true, but it also would be true to say that its object is to do justice. However, that's not the best way for aiding the court to find the appropriate meaning or the appropriate interpretation of the norms of the American Convention on Human Rights. If you wish, we can deal a little bit better with this in the future. A second idea that has to do with the interpretation of the court is a system developed by the court called the most favorable interpretation, or the pro homine interpretation. I think that a good way of showing the drawbacks of this technique is by going back to one of Aesop's fables. I don't know if you remember the stork and the fox. Well, it happened one day that Mr. Fox invited Mrs. Stork to have lunch. Mrs. Stork was delighted, so she decided to go and accept Mr. Fox's invitation. And he served some soup in a bowl, something with which Mrs. Stork couldn't deal. She couldn't have any soup. So then Mrs. Stork, who was a little bit angry with Mr. Fox, invited him to have lunch, and she served something in a vessel that had a very long neck, which Mr. Fox wasn't able to deal with. The teaching of the story has nothing to do with the theme that I'm talking about. The teaching is, if you trick somebody, you should expect that other person to trick you back. I'm not saying that the court does anything like that. I'm just saying that what is suitable for some people is not suitable for somebody else. Therefore, what is considered to be the most favorable interpretation for one person isn't necessarily going to be the most favorable interpretation to the other person. You may say, well, but that doesn't matter before the Inter-American system. Because before the Inter-American system, if you look at the procedure, you only have a person who is arguing against a state. Therefore, you have the rights only of a person who is arguing against a massive international actor who has no rights. The thing is that what procedurally appears like that conceals something very important, which is that there are often rights and interests that are concealed in this state position. There are some clear cases. For instance, let's say if a person argues that the state's curtailing of his or her freedom of expression is a violation of the American Convention on Human Rights, it may occur that at the domestic level there is a person who is arguing that his or her right to honor is being violated by this other person. So even though procedurally there's a person arguing against a state, substantively we could say that there are two people. There may be, it doesn't happen in all cases, but there may be two people who are both claiming a violation of their rights. We can deal with that afterwards if you wish, but there are two examples which have been very clear, both against Chile, so that's actually funny, but where this clash of rights was made apparent. The problem, this doesn't have much to do with the talk either, happens when the state, even though it has, let's say, a formal position before the court, which is against the victim, let's say, doesn't support that position, that formal position, so therefore its substantive position is the same as the alleged victim, and therefore the rights or interests that underlie the state's position procedurally may not be argued by anybody in a proceeding before the court. So that's an interesting point. So that's one of the drawbacks of that particular system of interpretation developed by the court, which is the pro homine interpretation of norms of the convention. Well, so far we've spoken about textual interpretation. However, there's another reality that has to be acknowledged, which is somehow crystallized by this quote, which is of Justice Holmes, which was a former US Supreme Court Justice. He says, "A word is not a crystal, transparent and unchanged. It is the skin of a living thought and may vary greatly in color and content according to the circumstances and the time in which it is used." That is very clear. I don't think it requires much more of an explanation, but there are some words which are very broad whose content may change, of course. If you have a word such as morals, well, 100 years ago, everybody would have agreed that a woman wearing a bikini would be clearly immoral. But nowadays, it would be very difficult to find somebody who says that. Another concept that tends to be used in these kinds of documents is cruel and inhuman treatment. Well, 100 years ago as well, the number of people who would have been in favor of corporal punishment would have been much greater than the number of people who support it nowadays, because the content of the word cruel and inhuman has changed. And that leads us to what has been called the evaluative interpretation of international human rights norms. Well, this idea of evaluative interpretation has been upheld by several courts, both domestically and internationally. The one perhaps that interests us the most is the European Court of Human Rights. The European Court of Human Rights has been using this tool for interpretation for a long time, and it subjects it to some kinds of rules. Those rules would be more or less the following. For a norm to evolve, it has to be framed in evaluative terms. What does that mean? That the term which is interpreted evaluatively should be open-ended, such as morals. The content of that would vary a long time, but there are some other norms that cannot evolve. If the court says 18 years old, well, that concept isn't a concept that may evolve. 18 years old is always going to be 18 years old, and something similar happens with many other concepts, such as death penalty. I mean, the death penalty is a single concept, and it's always going to mean, well, killing somebody because of what he has done or whatever. So there are some concepts which can evolve and some others which can't. So that's the first rule that could be said to be applied by the European Convention. Then another rule is that the evolution of a particular norm can't go against the intention of the framers. What does this mean? That if the framers of the convention, when they discussed a particular norm, made it clear that they didn't want to include a particular norm in the convention, well, that intention cannot be breached, if that would be the appropriate verb. And there are examples of this, such as the example of the right to divorce. Some people wanted to say, well, the right to marry in the European Convention on Human Rights, well, should allow me to have successive marriages. So I got married, then I want to marry again because I have the right to marry, so the right to divorce should be considered included in this norm. But the European Court analyzed the travaux préparatoires of the convention, and it said, well, actually this particular issue was discussed when they were speaking about this norm. Therefore, we cannot say that the convention has evolved, because for there to be an evolution, the idea to which the convention evolves must have been either explicit or implicit in the minds of people, in the minds of the framers. If they were going to frame the convention in these days, they should have been able to say, okay, we understand this, and probably it would have evolved in this direction. Of course, that there are many areas in which you could consider that the European Court made the convention evolve a little bit more than what the framers would have thought that the convention would evolve, but that's a different issue. But that's at least the principle that the court should, or that the court applies. And then an evolution of the convention cannot go against the text of the European Court of Human Rights. If it can't go against the intention of the framers, a fortiori, it can't go against the text of the convention. And then, other than besides those rules, it could be said that the court uses some kinds of tools for making the convention evolve or not. One of those tools is the European consensus. We may agree or not with the appropriateness of that tool. However, it is a tool which is more or less clear, and it tells us that that if there is a consensus among the majority of states, that could be a good indicator of the fact that the convention has evolved. Of course, that an evolution can't go against those previously mentioned rules, but if it doesn't say anything, and there is a European consensus, it may be considered that the convention has evolved. However, all these rules that you can find in the European Court are not stated by the Inter-American Court. So therefore, the evaluative interpretation is something which goes much beyond evolution. I mean, you could even say that in the American system it goes in what could be called a revolution, because the convention is made evolve in ways which actually sometimes could even said to go against what the convention actually says. And well, what's the limit? Well, the sky is the limit. That's the only limit for the for the Inter-American Court to make the convention evolve. So that makes it a little bit difficult for people who appear before the Inter-American Court to know where do they think that the court is going to make the convention evolve. Well, unless you know what what judges of the court think about particular areas. And this brings us to a different, to another rationale or idea when it comes to interpretation, which is that the court has limits when exercising its interpretive function. This was actually said by Judge Viodossi in a dissenting opinion. And what would be this limit? This limit would be that, according to Judge Viodossi, the court is in charge of adjudicating and not in charge of legislating. Those who are in charge of legislating are the states or whichever bodies are entrusted by the state with that mission. The convention is actually quite clear when saying that if you want to add new rights, you should do it following a procedure that is established in that convention. And this brings us to Article 29 of the American Convention on Human Rights, which is something a little bit specific, but I think that is very important because it has been said that is the basis for evaluative interpretation before the court, and it has even been called in Spanish they call it norma de reenvío, which some people call it a norma de reenvío, which means a norm that makes the court go and look into different legal bodies. Well, Article 29 of the American Convention on Human Rights is actually an abuse of rights norm. And again, it's easy or it's interesting to compare this with what happens at the European system of human rights. There is a very similar norm at the European Convention on Human Rights, which is Article 17, called the abuse of rights. This article at the European Convention says, nothing in this convention may be interpreted as implying for any state, group, or person any right to engage in any activity aimed at the destruction of any of the rights and freedoms set forth herein or at their limitation to a greater extent than provided for in the convention. What does this mean? That nobody could use a norm of the convention to destroy or render irrelevant another norm of the convention. A good way of understanding this is with the first case that the European system analyzed regarding this article. This is the case called German Communist Party and Walter Fisch versus the Federal Republic of Germany in 1957, which is quite soon after the Second World War. This case dealt with the German banning of the Communist Party. Well, after the Communist Party was banned, representatives of the Communist Party appeared before the European system, and they said, well, by this ban, we are being denied our right to freedom of expression, our right to freedom of opinion, our right to associate. The European Commission on Human Rights, in this case, didn't go into the court. The European Commission on Human Rights said, well, the problem here is that your statutes say that the mission of your party is to install the dictatorship of the proletariat and therefore destroy the democratic system and some other civil rights. Therefore, you cannot try to use the convention to defend you when your means are actually to destroy the rights and freedoms that have been enshrined in the convention. So that would be an application of this norm. Now we're going to go into the Inter-American Systems norm, which is a little bit wider. The first paragraph is very similar to that of the European Convention on Human Rights. The second one is a paragraph which is shared by many other conventions and human rights declarations. The third paragraph deals very much with the idea of natural law, which is a concept that by the time when the convention was framed was very much alive, especially in Latin American jurisprudence. And then Article D deals with the American Declaration on Human Rights, but that would be too much details for this talk. The thing is that the Inter-American Court of Human Rights says that letter B, which says that no provision of this convention shall be interpreted as restricting the enjoyment or exercise of any right or freedom recognized by virtue of the laws of any state party or by virtue of another convention, allows it to apply different norms. For instance, this is a hypothetical example, okay? Let's say that the norm that forbids discrimination at the Inter-American system were to say, well, discrimination can be made on grounds of ethnicity and race. That's something hypothetical. It's just so that we can understand this. And the domestic laws of a state were to say, you can make no discrimination based on race, ethnicity, and religion. The state shouldn't be allowed to say, well, of course I can discriminate on the basis of religion because the American Convention doesn't protect people on the basis of religion. The idea of that norm is to say, okay, you state can't do that. The problem is that it has happened that when a case is filed before the court has at times considered that thanks to this letter B, it can apply not only the convention, but also norms of different conventions, regardless of whether they have given or not a jurisdiction to the Inter-American Court. What's the problem with that? Well, first, that sometimes states have ratified those conventions precisely because they don't have any enforcement system. But also, it may have a problem for future states. It has happened that the court has interpreted some rights according to some conventions that have been ratified by some states, and then, since that interpretation started to form part of the Inter-American case law, it has applied it to some states which haven't actually ratified those conventions. And that is a little bit of a problem because it gives extra jurisdiction to the court. But that's only letter B. Letter C, however, hasn't been applied. But it says that no article of the convention shall be used for precluding other rights or guarantees that are inherent in the human personality. Imagine, the court may say, well, this particular right isn't established in any law, in any domestic law, in any convention ratified by the state, nor in the American Convention, but it nevertheless is inherent in the human personality, and therefore I could adjudicate on that particular right. So that would open up a Pandora box and make the Inter-American Court have, let's say, universal jurisdiction to any right it would consider to be appropriate. And the problem with that is that that would depend on the judges who are forming part of the court. And well, Article 29 is actually very, very complex, and originally I was thinking about making this whole talk about Article 29, but then I said, well, a talk entitled Article 29 of the American Convention wouldn't be very appealing. So I said, well, I'm just going to say a few things, and just if people have any questions, we can speak a little bit about this. Well, this is more or less all I wanted to say about the Inter-American system. Inter-American interpretation of the Convention. However, I don't want to give the wrong impression. I have actually dealt with a specific problem of the court. And with this talk, I don't want to be dismissive of the importance of the existence of a supranational court, because it is actually very important. It has been fundamental when it comes to protecting some rights, such as well, not being subject to enforced disappearances and so on. But I do think that the only way for having a court which is actually respected and whose judgments are taken into account is by having a court which is respected internationally and which has and which has prestige. And the only way of achieving that is by having a court is by pointing out some defects in the decision-making process of the court, so that the court can improve that. Because I do think that it's very important to have a court, especially in a system like the Latin American system, where we have had the speciality of human rights violations for some time. And that would be all the talk. I don't know if you have any questions so far.
Well, thank you for that talk. I congratulate you on your overall project, which is asking us to be reflective and careful about what we all think of as a good and a strength, the Inter-American Court and its role. And I appreciate you asking us to be careful about protecting the court's legitimacy to put words in your mouth. But I wonder if there's a little bit of a tension between the two parts of your talk. The first part of your talk said, look, the framers were very, very careful. We have to make sure that we respect the will of the states who drafted this convention. And then you end with, look at the convention and how broad Article 29 is. It's the same states that drafted Article 29, which seems to allow a lot of, many doors for the jurists at the court to walk through to interpret the convention. Is there a little bit of a tension between those two observations?
Well, the thing is that I actually think that Article 29 is not being applied appropriately by the Inter-American Court. I do think that the idea of Article 29, well, first, we should actually wonder, is Article 29 an article that should be applied by the court or by states themselves? That's an important question, because the convention says that the court is entitled to adjudicate on the rights and freedoms set forth in the convention. And this article isn't within that section of the convention. It is actually in a section which deals with the rights and duties of states, but outside the rights section. And you also can see that it says that no provision of this convention shall be interpreted as permitting any state, party, group, or person. And the court doesn't have jurisdiction over persons. The only entity that has jurisdiction over persons is a state. So I think that Article 29 was actually drafted as an article that should make states, that should be applied by states when interpreting the convention themselves. Why do I say this? Because the interpretation that the convention, that the court makes of the convention is an interpretation that is made very seldom, in the sense that it is, well, first, the convention can be ratified without giving jurisdiction to the court. In those cases, which is the case of Jamaica, Grenada, and Dominica, I think, the court has no point or no part in the interpretation of the convention. So the convention would be saying, okay, you state should be aware of this. So that's one idea. Then norms such as this one appear in many declarations and conventions which create no supranational body of adjudication. And are those norms idle? No. The idea of those kinds of norms is for them to be applied by states. And I think that Article 29 is actually a very difficult article to interpret. But I do think that the intention of the framers, and actually if you read the convention systematically, you would come to the conclusion that the idea of Article 29 is not to give extra jurisdiction to the court, but to set a limit to states which are indeed, even if they grant jurisdiction to the court, the ones that apply the convention every single day. I mean, there are, let's say, 12 cases decided by the court each year, but states apply the convention every day. Well, the judiciaries of states apply the convention every day. So I don't think that there's a tension. It's just the fact that the framers of the convention didn't want to do that. So therefore, if we respect the text, there should be no tension there. I don't know if that makes it a little bit clear, but yes, it is a rather difficult norm. And well, when I say these things, by no means I want to be like an originalist. I do believe that there is like a scope for evolution. However, I think that scope for evolution is something that should be framed within certain rules, such as those that the European Court of Human Rights uses. I don't know. Samuel.
Yeah, okay. Thank you very much for the interesting presentation. I have a couple of observations and comments, basically on the topic. So, I think your approach seems to me, and I'm sure you also admit that, it's more of positivist and legalist approach to human rights. But, I mean, from what I know, international law has kind of evolved through the, emergence of human rights through times, and I mean, human rights has contributed a lot to the evolvement and, to the development of international law. And one of the understandings in that is that there is a kind of human rights exceptionalism, in the sense that not all international law principles apply, even rules of interpretation apply strictly to human rights. There is some room for, some room for discretion and navigation while applying human rights norms. So the point I'm trying to make is that in human rights law, the focus is the individual. The focus is not the state. The state is just a means of enforcing the norms and standards that are set by the conventions, the various conventions. So the focus is the individual. So whenever we talk about interpretation and protection, we should focus on the state, we should focus on the individual rather than the state. Although the state is still a relevant actor.
Yes,
but
you are you are making
so
quite a few questions.
So we should keep that in mind. The other is the object and purpose of human rights treaties in general, not only the American Convention. The object and purpose of human rights treaties is to protect human rights of individuals and groups. That's the purpose. So whenever there is a need to interpret, we should interpret that confusion or whatever in light of that. So the object and purpose is to protect and promote human rights. And the other one is the intention of framers. The intention of the framers. The reason why the framers included Article 29 is because they knew that at that point in time they cannot include all rights. And they wanted a broader protection of human rights than the ones that are recognized under the American Convention. And it's clear, I think, while reading Article 29C, it's clear that precluding other rights or guarantees that are inherent, even if they are excluded by the Convention, then by interpretation they should be included. And B, as well, restricting the enjoyment or exercise of any right because by virtue of the law, it shouldn't restrict. And the sole organ that's dedicated to do the interpretation is the the Inter-American Court and the Inter-American Commission, not states. States are there to enforce, not to interpret.
Okay.
Yeah, and then, one last point. They are not there to interpret only the Bill of Rights that are included. These are guidelines included in the Convention for the Court and the Commission. Thank you.
Thank you very much. Well, there are different. You bombarded me with many questions, so I'll try not to forget any of them. Well, when you say that I have a positivist approach, well, I wouldn't like to qualify my approach the same way I wouldn't like to qualify the European Court of Human Rights approach. If you consider that the European Convention on Human Rights approach is a positivist approach, well, my idea, which is to make the Inter-American Court behave a little bit more similarly to the way in which the European Court behaves, yes, I would be qualified like that. I'm not asking for anything that I guess that would be enough for answering the first question. I'm just asking the court to set up a bit of rules in its decision making, the same way as the European Court of Human Rights does. Then I scribbled something which I don't seem to be able to understand, so I'll just go to the next one, which is, well, the focus of the court should be on individuals and not on the states. Well, what I said at the beginning is something that should be used for understanding a little bit what I wanted to say, is that the state's position often conceals some just different conceptions of human rights. Okay, so if you say that, let's say, the Inter-American Court of Human Rights suddenly considers that the norm of the right to life, which makes a reference to conception, has evolved, and therefore conception is a word that shouldn't exist there, well, that would be an evolution with no rules. By doing that, you're not necessarily focusing on the person instead of focusing on the state. By doing that, what you're just doing is taking one of these different conceptions, that ideas of human rights that are there, dismissing another one. So that's something that should be taken into account. When you take into account what the states decided in a particular point of time, you're simply taking into account a particular view of human rights. Then you say, well, another thing is that you say that focus should be placed on people and not on states. There is an exceptionalism of human rights international law. Okay. However, if a state simply decides to denounce the convention, what can human rights norms do? If a state denounces a convention, the Inter-American Court loses all of its jurisdiction regarding what happens in that state. So international norms apply in human rights law as well. And perhaps if you actually go against the will of states, which aren't necessarily against human rights, at least most states, but simply want to have a different conception of a particular, or a different conception on human rights. Well, if you don't take into account their will of protecting a different conception on human rights, it simply may happen that the state may say, well, the court is going beyond the mandate I gave it. Therefore, I will denounce the convention. And then there will be no way of protecting rights supranationally in that particular state. Well, there always is one way or another, but this formal means of protecting human rights would disappear, which is actually what happened in Venezuela for the wrong reasons. But it has happened also with other, at least with one other country, and with those states which had decided not to submit themselves to the court. And then, well, you say that the interpretation of the convention is something which should be made only by the court and not by states. I don't think that that's the case. In fact, it happens all the time with those states which have ratified the convention and haven't given jurisdiction to the court. They are the ones who apply the convention the way they consider it to be best. And it also happens whenever states, judiciaries of states, interpret the convention. And well, there is this doctrine of conventionality control, but that's too specific, and perhaps you should ask Paolo, who knows more than me in that area. And what else? You said that the intention of the framers when drafting Article 29 was to broader protection of human rights. My question would be, how do you know that? I've checked the Travaux Préparatoires, and that doesn't seem to be the intention. And well, we certainly have a different reading of Article 29. That's a different point. But the intention of the framers isn't explicit anywhere. I've searched for it in the Travaux Préparatoires, and it doesn't appear. Well, again, Article 29 is a difficult article, and that would require somebody to write an article on that particular topic and develop it a little bit more. Any other questions? Blessing?
Okay. My question is related to like your approach, which, if I got you well, which is like a minimalist approach to interpreting the convention. Then my question would be, how should the court be able to balance between giving meaning to the text of the convention and also taking into account the social political context of the member state which the case is before the court? Because there is one thing, acceptance of the judgment is not only based on the issue of direct interpretation of the text of the convention. You also find that even if you apply direct interpretation of the text of the convention without taking into account the political context of a particular member state, you can also get the same result, which is like the states not accepting the judgment of the court. Secondly, my issue is on the universality principle of human rights. As we all agree, starting with the Universal Declaration of Human Rights, and I mean the principle that is there that human rights are universal, which means that they apply across every society, every community. Of course, I know there are limitations. So how can the Inter-American Court, from your restrictive interpretation, be able to take into account that concept of universality of human rights? Because when we are talking about a norm, if it is a norm that has been accepted globally, it means also the Inter-American Court of Human Rights have to take into account that norm in its interpretation. Yeah.
Okay. Compatibilize the existence of a text establishing a right and the idea that that there are specific social conditions within a country. I think that question of compatibilizing the text and social conditions should be analyzed in a particular case, in the sense that you can't compatibilize the text of the convention with forced disappearances, for instance. In that sense, you have to apply the convention. Forced disappearances aren't allowed by the convention, and the state has no, let's say, margin. There's no way of interpreting the convention otherwise. However, there are some other cases where social conditions may be different. Like the example I said about freedom of religion. I don't know what's the popular agreement or not with the idea of having an established religion, but social conditions regarding an established religion there are compatible with the idea of freedom of religion in general terms. And that takes us a little bit towards your idea of rights being universal. Yes, indeed, human rights are universal when it comes to framing general terms. However, they are very specific when it comes to the embodiment of particular norms. I don't know, in the US, because of their understanding of freedom of expression, it would be just very difficult to propose a norm which penalized the denial of the Holocaust. However, if you take the context of Germany, considering that they lived that reality themselves and they know how hard that reality was, freedom of expression, I think, is compatible with the idea of restricting the expression of something that affected a particular country in a way that no other country can be able to imagine. And I think that, yes, you're right, rights are universal in their formulation. However, they are very specific when it comes to their actual embodiment in particular norms. And this idea is not mine. I think it was taken from Lord Hoffman's from the UK. Yes?
So, kind of just expand on that. When states and courts are taking this kind of, when they're taking a textual approach to the interpretation, and as you said before, there are ambiguities and gaps in the convention. So then where does states and the court turn after we've exhausted the tools of interpretation to resolve those ambiguities? And is that kind of where the differences in one state's, I guess, values versus another state's values? And does the court allow states to resolve those ambiguities on their own, or does the court resolve the ambiguities itself?
Well, that's one of the differences between the Inter-American Court and the European Court, for instance. The European Court is able to live with the existence of, I don't know if ambiguities, but with this scope for diverse interpretations of rights. And therefore, it grants states what it calls a margin of appreciation. So therefore, let's say, it allows, again with the theme of freedom of religion, it allows France to have this approach of laïcité towards freedom of religion, and it allows the UK to have an established religion. So it allows, I mean, it is comfortable with the existence of these different approaches. The Inter-American Court, by contrast, isn't that happy with the existence of these different ideas, and doesn't have the margin of appreciation, doesn't allow for the margin of appreciation as much as the European Court of Human Rights. There are different reasons that may explain that, but that's the actual situation. When it comes to interpreting something, the court says, okay, I'll interpret it the way I consider it to be best. Peter?
For another one, I have many comments. Thanks for your presentation. Maybe I would add one more label towards the ones that you have already received. And I see that I don't know if I understand correctly, but yours is a proposal for a more pluralist understanding of the American Convention. I guess that allows to fit different, still legitimate interpretations. For example, you have been insisting on the right to freedom of expression, for example. I guess I am reluctant to say that the more rights, the merrier. I see it a little bit, I don't know, I'm still struggling with that idea. Because the more I see legal intervention into personal lives, that goes exactly against freedoms and the rights of persons. I just think of the diversity in the region. We have countries with still guerrilla wars, other countries with a stronger democracies. We have countries that have no indigenous populations at all. We have other countries like Ecuador that have not only a lot of more than 12 people in a very small space, territorial space, but we have even people that have never contacted other peoples. So it's very difficult for, beyond those rights of right to life, the torture, prohibition, and other rights that have more or less a clear-cut interpretation and application. There are other things like the rights to association, the right to family, the right to what are in our case, for example, in Ecuador, we have a very what is due procedure when we have to also respect the rights to self-determination of indigenous peoples? Can they have courts? So I see that in your framework there would be more space for a pluralist interpretation and not just a vertical imposition from the court. And my question is, sorry for the long comment, but my question is, it caught my attention that you described that you refer at the beginning and then again in the middle of your presentation to these two things, that there's a specific procedure to add rights to the convention, and that you read the article, then you mentioned this article 29, not as applying to the court, but as applying to the states. And I was wondering, in the work that you did on the context of the travel preparatoire of the convention and how to the early application of the convention, I see that now when we think of the Inter-American system, is mainly a supranational and judicial. Supranational, one characteristic, and it has to be a strong judiciary. I wonder with these two comments that you made, if the American Convention or the American system was envisioned more for the participation of the states, whether the OEAs should have been stronger as a political space, the gathering of states parties should have played a more key role in advancing the human rights, and even the dialogue between states and the each other's faults might have been something that we're missing if we were to apply the Article 29 as you suggested.
Thank you. Well, I'm not very sure about the idea of the role of states. And one of the interesting points that you mentioned about Article 29 is that it's actually called restrictions regarding interpretation. And if the court were to apply it, instead of being a restriction regarding interpretation, it would be, I don't know, what's the antonym to the word restriction in English? Expansion. Thank you. It would be an expansion of the ways of interpreting the convention. So that's an interesting point, and that's something that you can read in the English version, but not in the Spanish version, because it's very different. And the role of states, it would be difficult for me to actually know that, but I think that probably that was the original idea, because as far as I recall, the idea by creating the American Convention was to establish a minimum. But at the same time, they knew that there were some states that wouldn't agree with certain minimums, and that's why but they still incorporated them in the convention. But I think it would be a difficult. I mean, your question would be very difficult. One would actually have to dwell much deeper into the travaux préparatoires, and that's a work that I haven't done when it comes to the convention. I've done it a little bit with the declaration, but not with the convention. But thanks especially for your first comment, because it was very interesting to hear about the idea of having a more pluralist approach. Thank you.
I think we're out of time, but I'm glad that this talk happened the Monday of your last week here, and so everyone, we have Alfredo for one more week. Let's take advantage of him. I hope that's all right if we do that.
Yes, and you saw my email. It was at the very beginning of the talk, and there it is in case you wish to send me an email or whatever.
On the posters probably too. So please join me in thanking you for such a thoughtful and
Thank you.
provoking talk.
Thank you. Thank you. I'm glad I didn't start coughing. Really? Thank you, Ma.